Calling the next case, People of the State of Michigan versus Evan Armogeda. This is case number 167760, a mini oral argument on the application, 15 minutes per side. My understanding, Mr. Wickman, is that you are sharing 3 minutes with Ms. McCann?
Correct.
Okay. For CDAM, and obviously 2 minutes fire free if you would like to waive, and then any time that you would like to save for rebuttal, please.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, I am Chris Wickman of the Nichols Law Firm, representing Mr. Evan Armogeda. In addition to the 3 minutes I will be sharing from my colleagues from CDAM, I would also ask to reserve 2 minutes of my time for rebuttal if available. The defense asked this court to hold that resentencing is required any time that the trial court did not properly calculate the guidelines prior to sentencing or resentencing. This is the holding of Francisco, which the defense is asking this court to reaffirm. The defense's position would also be consistent with the last 10 years of this court's rulings with regards to sentencing guidelines, including Lockridge. Under Michigan law, it is not enough that the trial court summarily state a sentence. Michigan law requires that the court calculate the sentencing guidelines, consult and consider them as a highly relevant factor, issue a sentence that is proportional to the offense and to the offender, and justify the sentence in order to facilitate appellate review. If it is an out-of-guideline sentence, the court must also articulate the reasons for the out-of-guideline sentence and support the extent of the deviation as well. The prosecution and amicus Pam would ask this court reject this court's decisions in the last 10 years and return us to the pre-Coles days where no sentencing guidelines existed and the appellate court could not review the trial court's exercise of discretion. If the prosecution's position should become law, a trial court could simply insulate its sentence from appellate review by simply stating that it would have done the same thing no matter the sentencing guidelines. Whether they know of any issues and whether there is a big or small change to the guidelines. The purpose of both the judicial sentencing guidelines, the legislative sentencing guidelines, as well as the proportionality analysis is all the same, eliminating unnecessary disparities between sentences. Whether you commit a crime here or 2 miles west, there shouldn't be a tremendous difference for the same individual. And adopting the prosecution's position will allow untethered restraint to run wild to the judiciary and likely force the legislature to step back in and begin to reestablish itself in limiting judicial discretion. This court should uphold Francisco and order resentencing in this matter. Despite the invalidation of the first sentence of 769-3410, it is a basic tenet rooted in the United States due process clause in the 14th Amendment to be sentenced based upon accurate information.
Counsel, let's say that I agree with the basic premise of your argument. Looking ahead, if the trial court here had said essentially everything else happened exactly the same, but we jump ahead and there is a full resentencing with the corrected guidelines, and when imposing sentence, the trial court says, look, my sentence was X, 360 months or whatever it was, because functionally this was a murder, but for the dumb luck that the person did not die. I think that this is the proportionate sentence, irrespective of what the guidelines are. I've considered the guidelines, but I'm considering really the conduct here, the background of the defendant, et cetera, et cetera. Would you still have an issue with that?
If the court followed the proper sentencing procedure, we would be here on a proportionality analysis, but that is not what the trial court did in this case.
Still challenging proportionality, but not necessarily taking issue with the statement, my sentence is my sentence irrespective of guidelines. I've considered them, but here, what's the driving factors, the underlying conduct, and proportionality.
And assuming I'm understanding the court's question correctly, if they had done a full resentencing,
Yep.
not that day on a later date, then I agree that that would be appropriate. This is a lawful sentence if the proper procedure is followed. But the big question is what is driving what? A result should not be driven by the process. The legislature has specifically designed the Michigan sentencing guidelines to be the process that drives the result. So if the court had in fact done the proper analysis, calculated the guidelines, considered them, established a factual basis for the reasons why they were justifying a 30-year sentence on this murder, well, on this not murder, but we have clients who are doing less than that on murder.
Right.
But if he had established that and established a factual basis, then that would be an objection to proportionality, and that would be a different situation, but that's not what the trial court did.
Thank you.
Thank you.
I understand the parties have stipulated on the correct guidelines range in this case. Is that correct?
Yes, that was done after the Court of Appeals opinion.
Okay, so we have the correct guidelines range, we have a departure sentence, and we have an articulation of the reasons for that sentence from the trial judge. So why would we require resentencing as opposed to just sending it to the trial judge to articulate the reasons for the departure?
A simple re-articulation or justification is not enough, Your Honor, for two reasons. First, I talked about the process should drive the result. The second one is that it has been 3 years since this incident happened. This court has made it quite clear you are sentencing the offense and the offender with regards to it. In this case, the judge did not know the guidelines, so did not articulate or strongly consider them. And when it comes down to it, this would be a new updated individual for Mr. Armogeda, for the victim in the case, as well as any updates on how he is doing. In this case, there was a lack of the consideration for what the guidelines should be. And when it comes down to it, a re-articulation is not going to allow Mr. Armogeda to allocute like he would at a resentencing. That's all things that the court can consider in its sentence. So I don't think a justification would be enough in this, Your Honor.
Counsel, the brother counsel and their amici suggest that this has the effect of making the guidelines effectively mandatory. And so obviously we want to stay true to Lockridge. How do you make those two consistent?
Yes, thank you, Your Honor. If we look at the comparison with the federal system, which the PAM and the prosecution has extensively focused on, they're based on Booker, and they have gone, in fact, in the same direction that we have, and that this court actually preempted them in Francisco, looking at Morales, where they have actually said that this is a strong consideration, that the guidelines are the starting point, and they have found that that is constitutional. I think that considering Lockridge indicated that these are a highly relevant consideration, I think that using that as a starting point is absolutely fine. I think if we look, especially comparing it to the opposite side, where if, for instance, the court can say, I would do the same thing no matter what the guidelines are, I think we're disregarding the last 10 years here. We're disregarding what Lockridge said about making them highly relevant. I don't know how the guidelines can plummet, and there's absolutely no, justification to a certain extent or difference. He didn't calculate the guidelines, such as in Gettert, did not justify any kind of extent. If I can swing back to Justice Zara's comment as well to incorporate here, the justification that the trial court gave was that the person could have almost died, which is very common in an assault with intent to murder. This is not a felonious assault. This is not some lesser charge. Assault with intent to murder. OV3 takes that into account. OV6, the intent to kill, also takes that into account. You can't be scored on OV6 and convicted of, you cannot avoid scoring on OV6 and be convicted of assault with intent to murder. That takes us 2/3, I think, or if not more, to maxing out your OVs. If you would say he was stabbed with a knife, you have maxed out your OVs based on that alone. So I think that the court did not justify it properly, why that is enough in an assault with intent to murder case.
Counsel, given your position that resentencing is required, do we need to overrule the Court of Appeals opinion in Latham then?
You do not need to overrule the Court of Appeals opinion in Latham because Latham is not directly on point in this case. Francisco is what is controlling in this case. Latham was a different situation that involved initially a downward deviation from the guidelines in the original sentence, then the guidelines moved to make it an in-guideline sentence. This, with the proper guidelines, is a sentence that is 5 years over the maximum and the 11 years over what the prior was in the mathematical. So I don't think you need to overrule Latham.
And so the difference being one's up and the other was down coming within guidelines, is that?
The biggest difference to me is that it's now an out of guideline sentence versus an in guideline sentence.
I see.
I know the court did pose that question specifically, so I don't think the court needs to overrule Latham.
Thank you.
Thank you. In this case, the court did not follow the proper trial court procedure for sentencing. They basically ignored kind of everything, including the extent of the deviation. If on resentencing the court does institute a 30-year sentence, and properly justifies it, then it's a different question, but that is not what the trial court did. So we would ask that this court order resentencing and hold that resentencing is required anytime the trial court does not properly calculate the guidelines consistent with Francisco. Unless there are further questions, I will welcome Ms. McCann to the podium at this time. Thank you very much.
Good morning, Your Honors. Jacqueline McCann on behalf of CDAM.
Good morning.
I would like to take, in the brief, we took a little broader approach in the first issue, arguing this is a Hegwood error, but I'd like to go even broader, a broader lens here to perhaps answer Justice Zara's question about why not just rearticulation, and Justice Welch's question where I think Latham can go and should go. You don't have to do it today because there is a difference between what I call a Kimball error, where the sentence is outside of the correct range, versus a Francisco error where the range moved, but the sentence is still within the correct range. And that broader lens is the following. This court has had a definition for actual prejudice in sentencing that requires a full resentencing since at least 1980. It is so embedded in our system that when this court created the 6500 court rules, that section, this court embedded that definition within 6.508. And that is this: if the sentence is there is actual prejudice requiring a full resentencing if the sentence is invalid. A sentence is invalid by definition of this court. In Francisco, they refer to Miles. Miles refers to Whalen. Whalen refers to Triplet, going back to at least 1980. Amongst the reasons a court has found that a sentence is invalid, this court, is when it is beyond statutory limits, when it's based on constitutionally inadmissible grounds, improper assumption of guilt, and very relevant for us, a misconception of law, when it confirms to local sentencing policy, or again, very relevant to us, where it's based on inaccurate information. In Francisco, this court found that using the wrong range is inaccurate information. I think there's also, it's also a misconception of law when you've made a scoring error. Those sentences are invalid sentences that, under Michigan's long-standing jurisprudence, entitle a defendant to a full resentencing, where they may allocute, and their defense counsel may allocute to the actual range that applies to them. And under our existing case law, Evans, which this court adopted in Hicks, if a judge says at a motion for resentencing or otherwise, nothing you say to me about my mistake of law, nothing you say to me about the inaccurate information that I relied on could possibly change my mind. Traditionally, we remand for resentencing before a different judge, because that means you are, again, going to impose an invalid sentence because you refuse to hear that your determination was based on a misconception of law or inaccurate information. And for those reasons, rearticulation is not enough. And for those reasons, Latham should fall, because that carve out in Francisco in footnote, I think 8, that says resentencing unless the sentence is within the correct range, absent scoring error, and also refers to Mucci. Those are based on the statutory language that the Court of Appeals must affirm a within guideline sentence, which is no longer valid post-Posey. And also, Mucci predated Smith, and that was before this court said you have to articulate the extent of the departure and the reasons for it.
Well, what kind of sentence can defendant realistically expect, given the trial court statement that it would sentence defendant to the same sentence regardless of which calculation was correct?
Again, Your Honor, when the court said that at the motion for resentencing, the Court of Appeals should remand for resentencing before a different judge. A judge who says they will not listen to you, will not reconsider the
But
new
there's-
information.
Is the judge really showing prejudice? The judge is saying, it could be this calculation, it could be that calculation. Regardless, this is the sentence I would impose. It's not a failure to listen, it's just, I recognize there are two calculations here. Whichever one would be correct, this is the sentence I would oppose. Well, I don't understand where the problem is on that.
My problem is this, Your Honor, as Brother Counsel said, the process is supposed to get you to the proper result, not I have a result in mind, and I'm going to post hoc rationalize how I got there. Again, doesn't let the defendant allocute. That's not a full resentencing, and if you take that away, where the rule has always been you get resentencing when there was an invalid sentence, and this qualifies under this court's definition for 50 plus years or so of what an invalid sentence is, you start to pull those threads. Why can't the judge just say at the end of the sentencing hearing, if I made any errors, I wouldn't change my sentence, whether that's any other traditional error, failing to let the defendant allocute, mistakenly thinking the habitual offender enhancement is mandatory rather than discretionary. Those errors, we get resentencing, a full resentencing. How would we insulate that from this, nothing would change my mind? Thank you.
Thank you, Ms. McLean.
May it please the court, Jerry Scrotenboer, Ingham County Assistant Prosecutor for Plaintiff Appellee. Both this court and the U.S. Supreme Court have said no resentencing where, despite a guidelines error, the judge says that the sentence would be the same anyway. This court's question whether resentencing is required, where the judge has clearly indicated that would have imposed the same sentence, but it does not fall within the appropriate sentence range. Now, this court already decided that issue. Back when the guidelines were first discretionary, we had People versus Hull, cited in the brief. Trial court mooted the issue concerning the proper scoring of the guidelines by explaining the sentence and stating that it was the appropriate sentence, even if it were deemed a departure from the guidelines, which is exactly what happened here. Now, then we have mandatory guidelines, and we have Francisco. Francisco did not hold what is in footnote 2. No. Footnote 2 is dicta, but the sentences were guidelines, but it was mandatory. Now we have things that are discretionary, and both Lockridge and particularly Steenhouse, opinions both signed by Justice Bernstein, said we're going back to Milburn. And what do we have? That puts us right back to Hull. That is part of the Milburn jurisprudence that we talked about. Now, the U.S. Supreme Court has said the same thing. Molina Martinez versus U.S. Defendant cited it up here, but gave the wrong name. Page 200. It says, it can be harmless error. The record in a case may show, for example, that the district court thought the sentence it chose was appropriate irrespective of the guidelines range. And the Sixth Circuit, at least, has jumped on that and has again and again said no resentencing in this situation. And I'll give you one. U.S. versus Morrison, 852 F3rd 488, 2017. An opinion signed by Judge Helene Nita White. In this case,
I'm wondering if you can help me out. Lockridge requires us, trial courts, to consult the guidelines and take into account when imposing the sentence.
Yes.
How do they do that if they don't have the proper guidelines range? How does that work?
Oh, he had the guideline range at sentencing. However, as this court has done many times, as pretty much any appellate court has done, it can say, well, we don't really need to take a look at what the proper guideline range or what. We don't need to decide an issue because defendant loses either way. And in that situation, that is what the judge was doing. And that's not the question that this court posed in its question.
How do you address Ms. McCann's argument that if we say that, you know, the threat that a trial judge can insulate review of its decision, of its sentencing decision regardless, by saying, doesn't matter, you know, even if I'm wrong on this or that, or I've missed something that I haven't even thought of, this is the sentence I'm going to impose?
Well, in the first place, this court has done many things like that, as I've just said. In the second place, this court, the U.S. Supreme Court, have flat out said that that is, in fact, what we do. We don't say, I don't believe you, Judge. In this case, the judge flat out said, well, it doesn't matter if it's over or under. Exactly what the judge said in the Morrison case. If it's within or over, this is the sentence I would give. And Morrison said, if the record shows that the district court would have imposed its sentence regardless of the guidelines range, then an error in calculating the guideline range is harmless. Defendant is asking for a major, major change in the law. Is basically saying we can't trust a sentencing court. We just can't trust him.
Counselor, is your position that the guidelines were correctly calculated in the trial court? Because I think that the U.S. Supreme Court law that's analogous would suggest that that's a basic procedural requirement. And so do you think that the court correctly calculated the guidelines below at the resentencing?
The court did not no, it was not a resentencing.
At the initial sentencing? Were the guidelines correctly calculated at sentencing?
No, they were not. But they were calculated, and they were calculated to the extent that anyone actually objected at the time. And under our rules, a defendant can come in at a motion for resentencing and claim, oh yeah, the guidelines were miscalculated, which is exactly what he did. And, well, then that means that the sentence is over the guidelines. And the judge said, this is the sentence I would have given anyway, and this is precisely the reason why. What he did was almost a murder. And he believed 30 was appropriate. Yes?
So opposing counsel made the point that a trial court could just insulate its sentence from review by always saying, I am going to give this no matter what. Can they do that? Can they just at the end of a sentence say, by the way, you can try like rescoring it or whatever, but you can't, I'm not going to change my mind. Is that enough? Is that how it works?
No, it's not. In
Okay.
fact, a Sixth Circuit case from last year, let's see, I have it here, where the judge said that. And the Sixth Circuit said, sorry, that's not good enough. Oh boy, where is it? From last year. I know I have it here.
Okay, so if that's not good enough, then what is your argument? What's different?
The judge explained exactly what it was. Let's say that we had this originally at sentencing, and we calculated the guidelines, and the judge said, I'm deviating upwards, or varying upwards, whatever, for this reason, and I'm giving 30 years. We wouldn't have a problem with it. So therefore, there's no problem with it here.
Counsel, I've got a practical question about this, and I guess it's kind of more dips into the area of policy. And it's simply, why not just do a resentencing? Where you know that the guidelines are wrong, the parties have now appeared to agree that the guidelines were wrong at the initial sentencing. Why not simply have a resentencing, impose the exact same sentence as before, explain why you're imposing 30 years again despite the change in the guidelines, and save yourself the headache of the next 30 years of motions for relief from judgment? Why not do that?
Because that would, well, for one thing, that would vastly change the law. We would have a rule that says, Judge, despite what all the courts have said forever, we don't trust you. We don't believe you. You gave good reasons for why you're going over the guidelines, but we're not doing it. Now, this court has said in Hull, when the guidelines were discretionary, as they are right now, that that's fine. You'd have to overrule Hull. You'd have to disagree with the U.S. Supreme Court in Morales, Mireles, and that is not a good thing to say, Judge, we can't trust you.
Counsel, what do you make of the counterpoint that it has nothing to do with, Judge, we can't trust you, and everything to do with a rules-based system? Say, look, whether you can trust the judge or not doesn't matter. These are the guidelines. We have a process. Send it back down. Have a 20-minute resentencing hearing, and then we're right back here. And now you don't have a defendant sitting in prison thinking he got a raw deal for 30 years. The process was correct. You reached the sentence the judge wanted in the first place. What's the issue with that?
Because the process was correct enough. Because the process was correct. He followed the correct rule. Nothing that the judge did at sentencing was wrong. The only thing that they're complaining about is at sentencing, at the motion hearing, where the judge was a quasi-appellate court, where the judge said, quasi, not entirely, of course not, quasi.
Giving them a chance to correct his error.
That is correct. And of course, if anybody would know, it would be the judge himself, where the judge said, as this court even said in Steenhouse, in a like situation, it doesn't matter which way it goes. The sentence would be the same. And the U.S. Supreme Court said that in Morales, Mireles, and the Sixth Circuit said that in, what is that case again, Morrison, and it saves, sure, it's not a new trial, but it still saves a lot of work for nothing, where the judge has clearly indicated. Now, what the Court of Appeals said in a case that I cited, we see no advantage of having the sentencing court march up the sentencing hill again, hand out the same sentence, which he said he would, and then march right back down again. That's the point. And that's why defendant is wrong. And a number of things. CDAM said that we've always ordered a resentencing. Well, that of course thoroughly ignores this kind of law. Also, in a case called People versus Triplett, which came out about 1990, where the judge had not given sufficient reasons for the sentence, and this was under the discretionary guidelines, this court's remedy was not a resentencing, but to remand to have the judge more fully consider, more fully state what the reasons are. Back when the guidelines were discretionary. Well, yeah, defendant is saying that I'm asking for pre-calls. No. Yeah, I'm the only person in this room who actually was a lawyer pre-calls, so I remember it. No, I'm not at all saying that. I'm not even asking to go back to Coles. I'm asking Milburn. Exactly what this court said in Steenhouse. We're going to Milburn. And Milburn incorporates Hull. And in Lockridge and Steenhouse, yes. The court said, let's make it discretionary. And it's discretionary in all respects. And it is, and that means that when we have a situation like this, where the judge flat out says it's discretionary, Defendant's trying to make it sort of mandatory again, no question. He's trying to make it as mandatory as it was earlier. If it's discretionary, that means that the judge does not have to follow the guidelines. And this court has never said that, oh, that was already considered in that guideline range, so that's not a good enough reason to deviate. Well, wait a minute, we're not deviating, it's above the sentence guideline. The judge has to consider them, and the judge did. In the Morrison case, the judge had given the sentence at the exact height of the guidelines. And he said, even if the guidelines are miscalculated, this is the sentence I'd give anyway. And the Sixth Circuit affirmed, said there's no problem here, based on the U.S. Supreme Court's statement. The only thing that defendant has is dicta in Francisco, when the guidelines were mandatory. Smith, when the guidelines were mandatory. All those cases when the guidelines are mandatory, this is discretionary. Defendant wants to go back, right back to mandatory guidelines. And it's rather interesting that defendant is making the same arguments that the prosecutor made in Lockridge and Steenhouse that this court rejected. So I am asking this court to either deny this application or affirm. Thank you.
Thank you. The case will be submitted.